Daily list item number 1.
My lord, for the item number 1, the conducting counsel is from Guwahati, my lord, so I'm seeking some time, my lord.
You're for?
I'm for the petitioner.
Petitioner or appellant?
Oh, appellant, my lord, I'm sorry. I
No,
apologize.
your case. Oh, the notice has been issued.
No, my lord, not yet, my lord. My lord, please give us some time so that during that course of time, then we will send the issues also, or notice to the other parties.
The first administration and counsel with the appellant who has submitted that this matter may be posted for admission hearing, and in the meantime notice may be allowed to be issued upon the respondents. We allow that notice be issued. Let notice be issued accordingly. Same returnable within 2 weeks. That will be posted. 2 weeks.
Item number 2.
May it please your lordship. Your lordship, as per the last order, we were supposed to get instructions on the status of the matter, your lordship. We're still awaiting the said instructions. So I pray for some time, your lordship.
What is this matter about, Mr.
My lord, this is a matter pertaining to land compensation, my lord.
Land compensation?
Yes. Here, my lord, initially a reference was made before the collector, but the reference was again sent back, directing the collector to cause an inquiry as to the disputes pertaining to the proceedings, my lord.
Old Act or New Act?
As per the old act, my lord. Because the proceedings were sometimes in the year 2010.
You are required to check on the status.
My lord.
Status, your lordship, yes.
As to what?
My lord, here the directions was given by the collector to the BDO, my lord, to the respondent number 3 here. Wherein, my lord, here the respondent number 3, I think, till date no action has been taken by him. We have, in fact, my lord, I've also annexed in my writ petition.
Oh, this is a writ petition?
Yes, my lord, this is a writ petition.
But if it is a matter concerning land acquisition,
yes,
then why have you come by way of a writ?
My lord, here we have not even received a compensation, my lord, despite some of the compensation have been paid to the beneficiaries.
Okay, okay. No, in that case, then there may be some dispute as to the title.
That's
and
what,
ownership.
lordship. Lordship, can you have page 90, annexure 12 of my petition, my lord?
Yes.
My lord, this is the order passed by the special court. Lordships, kindly have page 95, para 23.
Yes.
This reference is sent back to the collector, who will take necessary steps by identifying the dispute, if it is with regard to the interests of the land or with regard to the determination of fair compensation. that reference being sent back shall not bar the collector from making fresh reference after identifying the terms of the reference. Now, my lord, pursuant to this order, my lord.
So, pursuant to this order, no steps has been taken.
Next page, my lord. Here the respondent number 2, the revenue, has directed the respondent number 3 to cause an inquiry.
Your Lordship, we have sought for instructions on the status of this inquiry.
And after this, my lord,
So we
nothing
can
has
place the
happened.
same before
I've
this
also
court.
annexed the RTI information which you've received.
So, you check on it.
Yes, Your Lordship.
Miss Sadinography, Leonard GA, has sought for some more time to apprise this court of the status of the issues raised before this court by way of this petition. According to the Leonard GA, the same is required prior to filing of the affidavit in opposition if so necessary, if deemed necessary. Accordingly, on preemit, same not be objected to by the then counsel for the petitioner. The state respondent is directed to file the status report within the directed weeks. How long?
2 weeks, Your Lordship.
This is matter of the 2 weeks.
Obliged, Your Lordship.
Item number 3.
May it please, Lordship. Lordship, if Lordship kindly have this order dated 24/6/2024, Lordship.
Yes.
Lordship has permitted the state to produce the documents regarding this principal Kaling dot, Lordship, since June last year, Lordship. Until date, they have not produced, Lordship. And in the last occasion also, Lordship, if Lordship kindly see this order dated 14/2/2025. Here also, Lordship has directed them to file affidavit with regards to that those documents, Lordship, to show that they have floated that advertisement with regarding to that post teacher. Until date, Lordship, they're not filing. And Lordship, if Lordship comes to page 34 of the petition, Lordship, I just want to point out. Annexure 5, Lordship. This is a type copy, Lordship. The original copy is in Annexure 34A, in page 34A, Lordship.
Yes.
Lordship, if I may read, Lordship. This is to certify that Srimati Fulbidora Kelingdor has been teaching in Langja for quite some time. She is experienced and active teacher. She is qualified to be appointed as primary school teacher in place of her uncle, who is willing to apply for voluntary retirement to enable her to have this post, Lordship. So this recommendation letter was sent by this Deputy Inspector of School, Longstein, Lordship, from their office, Lordship.
How can it be? How can it be? You see, when there is a selection process in vogue,
Lordship,
she has to go through those.
it has to go through. Lordship, what I'm saying here is, Lordship, the service of this petitioner is continuous in nature, Lordship, and they have clearly said in their recommendation letter also, Lordship. And other, Lordship, in page 76, if Lordship see, page 76.
You mean you are stressing on the fact that her service has been renewed annually.
Annually, Lordship, continuously, and meaning like annually, but she has served
without any break.
without any break, Lordship. 76, Lordship. Lordship. See, this same recommendation letter was sent by from the office of the Subdivisional School Education Officer, Lordship, from their office only, saying that, Lord, if I may read, Lordship, since Srimati Fulbidora Karlingdor has been rendering continuous and satisfactory service for more than 12 years with effect from so-and-so, regularization of service may kindly be accorded at Langja Government LP School in the vacant post course wise so-and-so, Lordship. Even their department are saying that I've been in the service for more than 12 years continuously, Lordship, unsatisfactory. Until now, Lordship, they're not producing those documents to show that my service is not continuous in nature. Lordship. When Lordship asked the state to produce those documents regarding this principal killing, the person who has retired, Lordship, they failed to produce that also since last year. So, Lordship, this matter will prolong like this, Lordship.
Your Lordship, this matter is being conducted by Mr. K.T. Charging, Your Lordship. I pray for some time on his behalf to file this after this.
If they're not filing, Lordship may close the matter and we can file a written argument, Lordship.
Your Lordship, because we've stated that there was a selection process, Your Lordship, and the petitioner was allowed to participate.
Okay. You have stated that in your counter?
Affidavit, Your Lordship.
Anyway, Mr. Charji is not here.
Lordship has been given them ample of time, Lordship, since last year.
Prayer has been made on behalf of Leonard G, Mr. K.P. Charji, who is, I know, Mr. Leonard G has sought for accommodation on behalf of the state respondent on the ground that the Leonard conducting counsel, Mr. K.P. Charji, is indisposed. On prayer made, the same is allowed. List this matter tomorrow. So we'll take it up tomorrow.
Tomorrow, Lord. Deeply obliged.
Item number 4.
My Lord, this matter involves as to whether the reference court entertaining the reference application and passing an award in favor of the claimant 10 times from the original market value determined by the collector is legally permissible or not. Now, in their
No, the award is to be determined by the collector.
Collector has determined 80 rupees per square feet. Matter went to reference court. Reference court has determined at the rate of 800 rupees.
Enhancement, my Lord.
Enhancement. So more than 10 times of the original award.
There must be some justification there.
My Lord. Therefore, we assail this order. Now, the Section 4 under the All Act, Section 4 notification was published in 1987 to acquire, my Lord, a plot in Police Bazaar for the purpose of a construction of office for the appellant. Now, later on, the matter went to Guwahati High Court. Guwahati High Court passed an order, reduced it to 3,000 square feet. So, corrigendum was issued, and the matter went to High Court again. And High Court passed an order, matter went to Supreme Court, came back, and finally reference was made. And collector stated that he has determined the market value at the rate of 80 rupees per square feet. And award was asked to receive by the appellant, by the landowner. Landowner claimed that he received under protest. Matter went to a reference court. There was a thorough examination of all the parties, and now she has passed an order that enhancing to 800 per square feet. Now I'll take the few annexures to the documents are lengthy, but the issue is very limited. My two principal grounds are that, my Lord, the reference was barred under the Act. The reference application was filed after 13 years. 13 years of the award.
13 years.
13 years. Even assuming that, my Lord, they come to know after High Court passed an order, still then the reference application was filed.
Let me understand properly. When all the formalities have been completed, and the collector has passed the award, so the respondent would have received the award under protest at that point of time.
At that point of time.
Or the relevant point of time, whatever the
Yes,
case is. Thereafter, after 13 years,
Well,
the
reference application was filed.
Section 18 was filed.
Well, in 2016, reference application was put up again. And on that basis, collector has referred the matter to reference court. And that's what is the first ground. Second ground, mainly, that the trial court was committed an error, but the reference court committed an error, counting the period of the date for determining the market value was made of 1991 instead of 1987. Now, my lord, I'll take a few annexure.
Yes.
My lord, may I come to paper book? Lordship, can you refer to paper book? Paper book, my lord.
Yes.
Annexure 1 is the section for notification. Page number 1 of the reference, the compilation. Now, 30 June 1987.
Yes.
Area mentioned is 480 meters in Police Bazaar. This was issued under Section 4 of the Land Acquisition Act.
Yes.
And page number two is a Section 6 declaration, 14 January 1988. Now, thereafter, the landowner has approached the High Court, saying that a certain plot of the area, certain part of the land, proposed land, is required by the landowner. Therefore, approached the High Court, and High Court passed an order, my lord, page number 3, 1991. And operative portion, page number 6, para 12. My lord, for what has been stated above, we direct the respondents to modify the impugned notifications and such as issued under Section 6 of the Act by reducing the area from 480 square meter to 3,000 square feet of the area included in the above notification, and after modification it shall be published in the Gazette. So, my lord, the Honorable Guwahati High Court reduced from 480 to 3,000 and direct the government to modify the Section 6 declaration. It didn't touch Section 4 notification. Lordship may kindly keep in mind. Section 4 notification remained as it is, but Section 6 were directed to modify it. That was the direction. And subsequently, my lord, the corrigendum was issued, page number 20. Now, 23rd December 1991.
Yes.
It says, please read 3,000 square feet in place of 480 square meter, appearing in this department notification that June 1987, that is Section 4 notification, declaration of 14 January 1988, published and such. So this was the modification, reducing correction of the area only, and Section 6 declaration, page number 21. Accordingly, Section 6 declaration was issued, page number 21. Under Section 1, Section 6(1) of the Land Acquisition Act, 4 January 1993.
This is the revised Section 6.
Yes, revised Section 6. in the middle now. Therefore, it is hereby declared that the land measuring about 3,000 square feet. Last paragraph. This is a partial modification of this department correction terms published and such. So this is the correction, the section 6 declaration. Thereafter, my lord, the writ petition, the landowner approached the Honorable Court, High Court again, saying that this correction was made in her absence without proper inquiry in her presence. Therefore, the Honorable Court, High Court, page number 22, judgment dated 23/8/1993, pass an order. My lord, the operative portion, page number 33.
Yes.
Page number 33. Paratyo. It says, considering the above overall circumstances of the case, the petition is disposed of in terms of the following order. The notifications dated 23/12/1991 and such are quashed. That is section, my lord. Those partial modifications were quashed. The collector himself shall conduct the survey in presence of the parties, and division of the land shall be made in equitable manner and not on the basis of arithmetical calculation. The survey shall be completed within 2 weeks from the date of the receipt of the copy of this judgment order. 2 weeks thereafter, completing the survey, the state shall publish a fresh notification in the nature of section 6(2) of the Act. So what my lord, the Honorable High Court directed is that my lord, quash the earlier modification, section 6 modification, go for fresh inquiry in presence of the party and demarcate the land properly and issue a section 6(2) notification. So section 4 notification was as it is. Only what it was done was section 6. Section 6 method. Thereafter, my lord, page number 35. Accordingly, as directed, method was done in the presence of the party, and later on, my lord, this notification was issued, declaration was issued. 17th September 1993.
Fresh declaration.
Well, fresh declaration, my lord. 17th September. And this was the last section 6 declaration. My lord. And thereafter, my lord, the collector made a statement that he passed the award on 18th November 1993 itself. And during that time, my lord, the original landowner claimed that he received the amount under protest. Now, pursuant to the agree with the High Court order regarding the re-survey and demarcation, the original landowner traveled to Supreme Court, and Supreme Court passed an order, page number 37. Dismissed the special leave petition, and therefore, my lord, by this order, 1984, the Honorable Supreme Court refused to interfere with the High Court order. So, order for fresh survey and issuing a fresh notification stands completed, and therefore the notification was issued. Thereafter, my lord, the page number 38. There was a dispute by this judgment, 2003. There was a dispute that when the landowner approached the collector to receive the amount of the protest and asked for reference, the collector informed the landowner that you have to pay the ad valorem fees before the collector referred the matter to the reference court. So in view of that, my lord, the original landowner approached before the High Court again, and High Court has passed this order. 25/8/2003. And my lord, the last portion, page number 41,
No, this is an appeal.
But matter was approached by a single bench against a single bench order. Matter reached to division bench.
Where is that?
But single bench order is not available, but single bench order stands merged with the division bench. Therefore, as per the available record here, but division bench order is here. Now it is clear, my lord, if I take a lordship attention to para 3 of the page number 39.
Yes.
It is clear. The prefix, after the orders passed by the Land Acquisition Officer, the above named claimant move an application under Section 18 of the Land Acquisition Act before collector for reference to the civil court. Those applications were rejected by the collector by its order and such on the ground that the application cannot be entertained unless ad valorem fee is paid by the claimants on an amount of compensation sought to be enhanced. Agreed by the said orders passed by the collector, the respondent herein prefer the petition. The learned single judge has held that the application under Section of the Act for reference to the civil court does not require payment of ad valorem fee. As such, the collector was not right in rejecting the application on the ground that ad valorem court fees has not been paid, and consequent thereof, the learned single judge had given a direction to mention hereabove. So, being agreed with that, my lord, the collector has filed an appeal, and this appeal was dismissed. My lord, page number 41.
Yes.
The collector shall proceed with the case as directed by the learned single judge. Now, the learned single judge say that there is no question of payment of ad valorem fees, so you have to take appropriate action in accordance with law. Accordance with law.
Yes.
And thereafter, my lord, page number 42, 2006, my lord, 4th August. This notice was issued to the landowner respondent. Notice has been given that in the above case in which you have been treated as interested person, an award was made by me on 18/11/1993. It's important. Under Section 11 of the Act. The sum payable to you is 3,98,400. Such. If you are willing to accept payment, you should be paid before me personally on such. So this was the award notice. So this arrived for 3,86,000 at the rate of 80 rupees per square feet. Now, being agreed with this, page number 43, reference application was filed.
Yes.
Well, so this reference application was filed on page number 44, 18 August 2006. At the bottom.
Yes.
Well, whereas, my lord, award was passed on 18/11/1993 under Section 11. So if we read, my lord, Section 18 of the Land Acquisition Act, agreed party can file a reference application within 6 weeks if he or she presents before the collector at the time of passing the award. If not presents, 6 months. Now, it appears, my record shows that reference application was filed in 2006. So if we go by that, it is more than 13 years. After 13 years. 13.
But what about this, your award under at page 42?
Page 42.
This is,
my lord, they
this is
came.
2006?
My lord, that is what he said, my lord. 2006. But it says that the award was passed on 18/11/1993. Now, even if we assume, my lord, a word comes to the knowledge of the petitioner by the original in the year 2006.
See, Mr. So if I understand correctly, from what you have led this court through, when this award was passed, proceedings were initiated before the High Court,
Yes.
subsequently Supreme Court,
Right.
so on and so forth. And by virtue of the order of the division bench of this court,
Yes.
the collector was directed to pass the award.
But award already passed.
Pass the award, no doubt. But see, the actual award the actual award to be passed, we can presume would be effective from this date only, 2006. Yes, that is, of course, that is the understanding of this court. It's up to you how you interpret it.
But if we
That
go
is only on the issue of delay.
yes, limitation. Now, if we go by the page number 39, where the fact was reproduced by the High Court, a word was passed and reference application was moved, and it was rejected on 21 May 1996. So that means he was very much aware of the award, and therefore he came forward and filed an application for reference. If he's not aware of the amount, there is no question of filing application for reference. So he was very much aware, and he moved the application. That was rejected. Matter went to High Court, and High Court said that question of ad valorem payment, ad valorem fees payment is not required. You proceed. So collector is supposed to proceed with that from that moment. Now, once the reference application was rejected, well, that in view of the High Court order, the reference application filed by him was supposed to be revived by Humber's submission, but it was not.
I don't understand the logic there. The reference was made by the collector.
Yes.
It became a subject of, subject matter of a petition before the High Court. As far as that question of ad valorem court fee is concerned, that issue was settled finally. So what we can assume is there is a series of proceedings. It's a continuous proceeding.
That's correct. They filed application for reference, but since the ad valorem fees was not paid, collector rejected application. So the application filed by the owner was then rejected. Being agreed with it, they went to High Court. High Court interfered, single bench division bench, directed the collector to you proceed, don't ask ad valorem fees from the landowner, you proceed in accordance with law. So the order passed by the collector was nullified by the High Court. So collector was supposed to proceed, acting on the first reference application, but there was nothing. Therefore, later on, after the High Court round of litigation was over, collector issued notice to him that you come and collect this amount. And then by 2006, he came and filed a reference application, which is, according to me, incorrect. It should have been proceeded from that 1993, 1994 application, whatever, which they filed. It should be proceeded with that. But he also came up with the fresh reference application. Therefore, the question of delay arises. Assuming that, my lord, the 2006 reference application is a repetition, is a reminder to the original application filed by the landowner, collector was supposed to proceed on that basis. But the record shows that collector also forgotten that one, landowner also forgotten that one, and collector and the landowner proceeded with the 2016 reference application. And matter would refer to the reference court. My lord.
And why was this issue not agitated before the reference court?
That was not raised.
My lord, in the reference court, the question of delay application, those pleadings are there. Pleadings are there.
Not in the written statement.
And decided accordingly.
That was not answered.
Not an issue also.
That was not answered. We'll just see the pleading, but
Okay.
that will answer. That will answer. So, my lord, page number 45 is the reference by the collector, 30 August 2006. And my lord,
This is reference.
reference by the collector to the special judge. In my lord mechanism, page number 48 is the claim petition filed by the claimant, the respondent here. Detailed claim they have filed. At that point, two claimants are there. So my lord may kindly see para 1. They do admit that notification. Claimant states that the government of Meghalaya by notification the 30 June 1987 which was published in Meghalaya Gazette and such, stating that more than such and such. So this is the Section 4 notification. Pay to admit. So the Section 4 notification was never revoked, but never changed. This is a pleading. Now,
But this refers to that 480 square meter land.
4 meter, because in the first Section 4 and Section 6,
Exactly.
480 was mentioned. So the High Court directed the collector to modify the
That
480 to 3,000. So admitted date of notifications, my lord, was not at all changed. What was changed was the area of the acquisition. But acquisition was never entered by the High Court. But therefore, the Section 4 notification was issued in 1987. But that is the benchmark. But now they admitted and they narrated, my lord, and I'll come to, my lord, the claim amount they made. Page number 54. According to the assessment of the claimants, respondents, my lord.
yes.
Cost of the land is 1,200 per square feet. Into 3,000 square feet, it comes to 36 lakhs. Cost of 2 houses were there. They claim for 7 lakhs 20. These are the claims, my lord. Now, pursuant to this, the party has filed, the claimant has an annex, page number 80, to determine the market value. Madam, sale date, madam, is made on this 31st December 1991. This is in Upper Lajumir. My lord, we kindly see now the land is situated, my lord, in the second paragraph.
Mr. Secretary, you're relating the facts of the case.
Yes.
But by referring to this page 80, now you have touched on the evidence. This was really part of the evidence.
But this is an annex.
When it comes to that, then you take the evidence.
Madam, in that case, my lordship permission, I'll straight away go to the WS file by the collector. Then I'll come to some part of the evidence later. But lordship, kindly come to, my lord, then page number 127. This was a WS filed by the collector.
Yes.
Well, para 2 entries say that he determined, my lord, the market value determined by collector was 800 per square feet. Well, para 3, it says that the land acquired as per market rate of 1993. This is also wrong, my lord. In fact, Section 4 notification was out in 1987, but collector is referring to 1983 market rate. Hence, the rate assessed is reasonable. There is no reason to say that the said amount is too low according to the land rate fixed by the Deputy Commissioner with regard to the calculation of attempts stamps for the purpose of registration of land in Police Bazaar. The rate per square foot in Sansan was rupees 80. This is in reply to the statement made in Sansan. So, collector briefly say that he determined the market value prevailing in 1993. I'll show how it is wrong also. Anyway, my lord, the rate was 80 rupees, so it is reasonable. So you're asking for 1,200 per square feet is absolutely wrong. That was a brief reply of the collector. The bank also, my parties WS available, page number 130. 130.
Yes.
My lord, kindly para 3. The instant claim petition is barred by law of limitation waiver estoppel. So they have taken a specific plea.
Yes.
And moreover, my lord, we come to page para 7. page number 131. My lord, the claim is otherwise barred and precluded from filing this claim petition, and only on that ground the claim petition is able to be dismissed upon the preliminary hearing on the issue of maintainability of the claim petition. So there was a specific plea taken by the bank that the reference application was barred. Now, thereafter, the party, my lord, deposed before the reference court, and deposition of the claimant is page number 138.
130?
138, my lord. 138. So, para 2 and 3, my lord, they admit that there was a section 4 notification, early notification was there. They do admit. Now,
Yes.
thereafter, my lord, another affidavit filed by the claimant number 2, witness of the claimant, my lord, page number 175. And I'll go to, straight away go to, my lord, the impugned order thereafter. Because the issue is very short. I'll come to that issue only.
Para
But page, the impugned order would be page number 253.
2?
253.
253. So you have referred to this deposition of Sid Blue 5.
My lord, the
No observation.
depositions are there, but my lord, the issue taken by me before, my lord, the deposition given by those parties are not relevant. I'll narrow down to the core issues only. My lord may come to page number 282.
$282.
282, madam. 282. 282.
Yes.
Madam. It says in the middle, madam. None of the other claimants' witness could substantiate that the price of land was ₹1 to not, madam. As per sale deed at Exhibit 2, dated 31st December 1991, the plot of land situated at Police Bazaar measuring 835 square feet together with structure was sold for a sum of ₹5 lakhs at the rate of 599 square feet. Well, this is inclusive of the house and the land. Now the collector, my lord, the collector has, the reference court has given more than that also. Now, as per sale deed Exhibit 3, dated 1992, a plot of land situated at Thangiti, measuring about such square foot, was sold for a sum of such, that is at the rate of 250 square feet, 1992, madam. Whereas the Section 4 notification was 1987. Now, as per sale deed, madam, the next page. As per sale deed Exhibit 4, dated 1996, madam, the collector has the matter was referred to 1996. A plot of land situated at MG Road, Sunset, fit along with multi-story building was sold for Sunset at the rate of 1,624 square feet. The claimant examined Sunset. Now, as per the sale deed Exhibit A, dated 1988, but this is in fact relevant at that point of time. Well, the plot of land measuring about 3,000 square feet at J Road, Shillong, was sold for a sum of Sunset at the rate of 15 square feet, 1988. Well, as per the sale deed Exhibit B, dated since 1989, the plot of land measuring about Sunset acres, along with 2-story RCC buildings standing thereon and situated Police Bazaar, was sold for a sum of Sunset at the rate of 383 square feet. It's very important. Now, may I come to the next page? Now, in the middle, the award was prepared by the collector, Deputy Commissioner, for a sum of Sunset on Sunset. Now, notice under Section 4 was issued by the Government of Meghalaya, Sunset 1987, which was published in Sunset, stating that the more or less Sunset meters of land This was with the boundary described in the notification was to be alienated for public purpose, namely for construction and such. However, by a later corrigendum, the amount of land was sought to be acquired was refixed as such. Subsequently, declaration such was issued and published in the Meghalaya Gazette such for the purpose. Therefore, the relevant date is very important. Therefore, the relevant date for computing the market value of the land should be reckoned from 23 December 1991 when the corrigendum was issued. In this regard, the sale date at Exhibit 2 would be relevant for the purpose of arriving at the market value. Now, my lord, corrigendum 23 December 1991 was quashed by the High Court. It was quashed by the High Court. I'll just show that quashing order. But that notification, my lord, may turn to page number 20 of the paper book. That corrigendum notification. Page 20. Well, 23rd December 1991.
Yes.
So reference court was referring to this. And this notification corrigendum was quashed by the High Court. My lord, can you see page number 33 in the petition filed by the claimant himself. Page 33. Para, my lord, Paratyo, considering the above circumstances of the petition disposed of in terms of the following order. The notification dated 23 December and such were quashed. Therefore, my humble submission, my lord, the reference court committed an error referring to a notification which was already quashed by the High Court. And that 1991 was the benchmark for the reference court to determine market value. This is wrong. This is wrong. Therefore, the finding arrived by the reference court, which we refer in page number, my lord, 284, my lord. 284
Yes.
is without any evidence. That is the first, the main argument. My lord, we place before my lord for lordship consideration. So this, the basis for determining the market value based on 23rd December 1991 is wrong. And second part, my lord, the sale deed, Exhibit 2, my lord, Exhibit 2, which, my lord, we have referred, page, my lord, page number, my lord, 282, which, lordship, we have just perused, page 82. As per the sale deed Exhibit 2.
Yes.
And this exhibit 2 is available at page number 147. My lord, we come to 147. Well, this sale of the sale deed is made on this 31st day of December 1991 between such and such. My lord, the second reciter, whereas the seller is lawfully seized and possession and otherwise well and sufficient is entitled to the plot of land, together with the shop house is important, my lord, standing thereon, situated Police Bazaar, MG Road, Shillong, plot number such. My lord, the next paragraph, and whereas the seller has agreed with the purchaser for the absolute sale to him of the said premises and the inheritage thereof in possession free from all encumbrances at or for the price of 5 lakhs. Now, may come to my lord, may come to schedule of the land at page number 152.
Yes.
But all that piece and parcel of the land measuring about 835 square feet, more or less situated together with a shop house standing thereon. So the 5 lakhs was the price of both the land and the house. Now, when we calculate this, it came into 599 per square feet of this 438 square feet. Now the reference court was relying on this, and the date of that, my lord, we come to operative portion of the judgment again, page number 482. I'm trying to shorten the argument because this is the issue only, my lord. Exhibit 2. Exhibit 2. Yes. That is page number, my lord, 147. This was in fact, my lord, 31st December 1991 was after even, my lord, the corrigendum referred by the reference court. The corrigendum referred by the reference court was, my lord, 23rd December 1991, which was caused by the High Court. But even assuming that this was still alive, my lord, the sale deed was admittedly 31st. And the law, my lord, I'll refer to section 18 read with section 23, is very clear. The market value would be, my lord, market value of the land would be the value prevailing at the time of section 4 notification. Now this will go further, my lord. Lordship, kindly come now to page number page number 284. Lordship is there. Yes. At the end, the ending line, my lord, the last line. Considering the materials on record and the location of the land in question, this court is of the considered view that market value of the land would be 800 per square feet. This is highly inflated. This is the grievance of the appellant here. Even assuming that, my lord, that 5 lakhs is only the cost of the land, it comes only 599 rupees per square feet only. Now the collector has, the reference court has come to 800. 800 is not even indicated by the sale deed also. Sale deed only indicates, my lord, 599 rupees only. That too including the cost of the structure. Therefore, this is the inflated enhancement given by the reference court. Now, from the evidence, it is established that the rate fixed by the collector was not according to the market value of the land at a relevant time. But this is absolutely wrong. Absolutely. But I'll come to my page number 287 now. Now the reference court has given 2 lakhs, my lord, 2,50,000 for the all structure. Yes. And the party, my party did not dispute about the all structure, my dilapidated condition was standing in that acquisition area. So that was not disputed, and that was considered by the reference court and awarded 2.5. But to that extent, my lord, we have no serious grievance over that. Only grievance is that 800. Now, page number 288, the last portion, my lord. With regard to the claim for the cost of premium, frontage and sunset may reduce or substantiate the claim for assessment on frontage land. Hence, no compensation is awarded under this head. With regard to the claim for the loss of potential value of the land acquired, no evidence has been adduced by the claimant. Hence, no compensation is awarded. The claimant is thus entitled to total compensation of 2650 for the land and structure standing thereon. And after adjusting the amount already paid, the claimant is entitled to compensation of 22 such. In addition thereto, claimant is entitled to solution of at the rate of 30% on the enhanced amount along with the interest at the rate of 12% with effect from the date of publication of section such. Now, if we go by section 4 notification, it is 1987, not 1991 also. Now, the enhanced amount, my 30% of the enhanced amount, it will come to a huge amount. That's the grievance of the bank, the grievance of them. Whereas the claimant failed to produce the market value at the time of 1987, no evidence was shown. Rather, from our side, the reference court appreciate that 1988, it was 15 rupees per square feet. Therefore, even the 80 rupees given by the collector at that point of time was an accelerated amount. But my party was not agitated against that one strongly. So we are not pressing that point also. I must be very fair with that. So since 80 rupees was fixed by collector, and from our side, no agitation came forward, therefore I will not press that one. I would say that 80 rupees given by the collector was handsome, generous enough, but at that point of time. If we see the present rate of the land, that is unimaginable. It is completely different. We cannot compare with the present market rate and those 30 years ago, 40 years ago. So my humble submission is, my lord, therefore, the evidence, my lord, the date of determination for market value referring to 1981 is wrong, because Contempt was set aside by the High Court. 1987 Section 4, Section 1 remained the same. Market value should be based from that at that point of time only. Secondly, the sale deed and relied by the reference court is absolutely wrong. If it is assumed that it is correct, but that sale deed was registered after Contempt also. Not to speak of the Section 4 notification. Now I'll just refer to two sections and I'll close my argument. Section 4, my lord, may kindly see, of the Land Acquisition Act, 1894.
Yes.
Well, Section 4 preliminary notification is the foundation of the land acquisition proceedings, and LA Act provide the inbuilt provisions. May we come to Section 18 now, to determine, my lord, where the collector needs to, or the reference court need to, my lord, look the period for determination of the market value. My lord, may I come to Section 11, my lord? Section 11. The power of
Yes.
Madam, on the day so fixed or any other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objections, if any, which any person interested has stated pursuant to the notice given under Section 9 to the measurements made under Section 8 and in the value of the land. And at the date of the publication of the notification of Section 4, subsection 1, and into the respective interest of persons claiming the compensation shall make an award under this. So collector, my lord, collector would determine the market value prevailing at the date of Section 4 notice. Now may we come to Section 19.
Section
18.
Yes.
Well, Section 18 is for application for filing a reference application. So may I come to subsection 2. Subsection 2. The application shall state the ground on which objection to the award is taken, provided every such application shall make. If the person making it was present or represented before the collector at the time when he made his award, within 6 weeks from the date of the collector's award. In other case, within 6 weeks of the receipt of the notice from the collector under Section 12, subsection 2, or within 6 months from the date of the collector's award, whichever shall first expire. So that limitation part also, filing reference application, there was a serious delay. But I would not seriously emphasize with that, because other two grounds are strong for lordship consideration to interfere with. Now, when we read Section 23 for determination of market value, my lord, may kindly Section 23. This is the last section I want to refer. Subsection 1A of section 23 may come straight away. It says, but in addition to market value of the land as above provided, the court shall in every case award an amount calculated at the rate of 12% per annum on such market value for the period commencing on or from the date of the publication of the notification under section 4, subsection 1, in respect of the said land to the date of the award of the collector or the taking possession of the land, whichever is earlier. My lord, I want to emphasize that therefore the determining period for award is date of the section 4 notification. So admittedly this is 1987. Therefore the collector was wrong. Though I did not challenge, I will say now the reference court was wrong, ignoring my plea and referring to my lord 1981 core agendum, non-existence. Number 2, 1981 sale deeds is beyond the core agendum also. These two are absolutely wrong.
According to you, the determination of the cost of the land or the price value of the land should be in consonant with, rather should be prevalent to the period when the section 4 notification was issued.
Yes, yes.
Which is 1987.
87. And the judgment.
And the collector has come to a conclusion that the rate prevalent as on 1991 would be applicable.
And that time 80 rupees has given. 80 rupees.
And that's the collector's impression.
A collector has given 80 rupees per square feet that time. And now the reference court went further and relied on the sale deed beyond the core agendum also. And even the sale deed is assuming that it is true. It is only 599 rupees per square feet, including the cost of the house structure. But now he has given 800 rupees. On what basis? There is no evidence.
There is no justification.
There is no justification. So on these two grounds, my lord, Lordship may kindly can say in the far. I'll just place the two judgment and raise my submission, my lord. This with regard date of the determination, my lord. 1996, volume 3. ACC, my lord, page 766. Para 6, my lord.
Para 6.
Para 6. Page number 766. Para 6, my lord.
Yes.
Para 6,
yes.
It is well settled law that the burden of proof of market value prevailing as on the date of publication of section 4.1 notification is always on the claimants. I do not need to go down this principle elucidated by the Supreme Court. Now, my humble submission is that the claimants before the learned reference court completely failed to adduce evidence to determine the market value at the time of 1987. Rather, he brought another strange document late before the reference court, and reference court appreciate that one. That is wrong, madam. That is wrong. Another one, madam. The judgment may refer, my lord, 2010 volume 3, page 545. Relevant para, so I have cited, my lord. Relevant para 16, 28 and 30.
16?
28 and 30. May take a lordship one para, my
Para?
Para, my lord, 29, 30, my lord, to save lordship time.
29, 30?
29, 30. It says, a person who fails to make an application for reference within the time prescribed is not without remedy. It is open to him to make an application under section 28A of the Act on the basis of an award of the court in respect of the other lands covered by the same acquisition notification if there is an increase, be that is in May. When a person interested makes an application for reference seeking the benefit of 6 months period from the date of knowledge, the initial onus is on him to prove that he or his representative was not present when the award was made, that he did not receive any notice under Section 12(2) of the Act, and that he did not have the knowledge of the contents of the award during a period of 6 months prior to the filing the application for reference. This onus is discharged by asserting these facts on oath. Here he is not expected to prove the negative. Once the initial onus is discharged by the claimant person interested, it is for the land acquisition collector to establish that person interested was present either in person or through his representative when the award was made, or that he had received a notice under Section sunset, or that he had knowledge of the contents of the award, my lord. So throughout the entire record, my lord, even the claimant did not show where is his reference application he filed in 1993. Nothing was there. What he was pressing is in 2006. Inordinate delay. That is a second leg of my argument, apart from that first two, my lord. So, my lord, the judgment rendered by the learned reference court is absolutely not sustainable in law. For submission.
May please, Your Lordship. My lord, in as far as the delay is concerned, my lord, will kindly come to page 42. After all the, without taking Your Lordship's time, without, my lord, my learned friend has already referred to all the
Your respondent,
proceedings.
Respondent 1 or 2?
1.
Page?
1, 2, my lord.
Page?
My lord, we will kindly come to page 42, my lord. My lord, my friend has briefed Your Lordship in as far as the
Yes.
page 42, my lord. My lord, after all the matters has come to the High Court, and the subsequently the High Court has, the division bench has directed the collector to issue a notification under Section 12 for the declaration. This my lord will come at page 42. I may read, my lord. Notice hereby given that in the above case, in which you have been treated as a person interested, an award was made by me on 18/11/1993 under Section 2 of the Act of 1894.
11, I think.
Section 2, Section 11. The sum payable to you is so and so and so and so. I will come that. If you are willing to accept payment, you should appear before me personally on such and such date, 18/8/2006, 11 am. Interest will not be payable in case of failure to appear, my lord. On the basis of this, my lord, this is the word which has been given to me, my lord, after all the litigation was, after the initial notification under Section 4, my lord. So this notification is very important, my lord. This is on the basis of this particular notification, my lord, the award was awarded to me, my lord, in respect of the.
Yes.
My lord, on receipt of this letter, notice, my lord, dated 4th August 2026, my lord, I had put my application for reference under Section 18, which is under protest, my lord. Page 43.
Page?
Page 43, my lord.
This is your
This is my
protest.
application under protest, my lord. This is dated 18/8/2006, my lord.
Yes. 18?
18/8/2006, my lord. Page 44, my lord.
Yes.
Well, in as far as the delay part is concerned, which my friend has raised, my lord, there's no delay as such, my lord, because the notification has been issued under section 12, my lord, on 4th August 2006, my lord. And I was asked to appear on 18/8/2006, my lord. So on 18/8/2006, when I had appeared before the collector, I had put my application for the application under section 18, my lord. So there's no delay as such, my lord. This fact also will, your lordship will see that this plea also was not raised by the petitioner here, appellant here, my lord, not raised before the special judicial officer. The written statement which my learned friend has referred, my lord, it has been raised only casually, my lord. It's only now, my lord, that the delay.
Where are the issues framed?
Issues, my lord. Two 265. 265, issue number 1, my lord. Whether the claim petition filed by the claimant is maintainable, my lord.
Yes, and then
Learned counsel for the claimant submits that the claim petition is
what about there are how many issues have been framed?
issues, my lord? Issue
269 is issue number 2.
Issue 269, issue whether the rate fixed by the collector was according to the market value of the land at relevant time. Then, my lord, will come to
These are final.
three is 285, my lord. Whether the award was fair.
See, Mr.
My lord.
If you go to page 262, these are the issues framed.
Your lordship. The following issues have been framed by the court: whether the claim petition filed by the claimant is maintainable, number 1, my lord. Whether the rate fixed by the collector was according to the market value of the land at the relevant point of time. 3, whether the award was fair, reasonable, adequate. 4, whether the award for the structures of the land acquired is fair, adequate, and reasonable. 5, whether the claimant are entitled to enhancement of the award, my lord. These are the issues which are framed by the.
Mr. Sagresu,
This,
you have not suggested any issues
No, no.
as regard the
the delay.
delay.
But that is the maintainability, madam. That is the maintainability.
No specific plea was taken, my lord.
Okay. So this has been discussed in this under the issue of maintainability. And where is the finding of the learned special judicial officer as far as delay is concerned?
That was not raised, my lord. So there was no.
Madam, kindly see page number 165.
165?
Madam. Issue number 1, para 20.
165?
Madam, sorry, 265. 265. I'm still corrected. Madam, page number 268. There is discussion there. Therefore, 268. As per the statement of the reference made by the collector, the reference has been made as the landowner are not satisfied with the award made by the collector and received the award under protest. By notice and such, there was also notice, my lord. The opposite party intimated the claimant about the award. In 1993, the claimant filed an application for reference under section such. My lord, the delay, my lord. However, the same petition was rejected by the collector. Agreed by the said rejection, the claimant such which was disposed of by the order of holding the application seeking reference does not require payment of ad valorem fees, court fees. The matter being settled with regard to reference to opposition number 1 after a long gap, such requested the claimant to appear and accept the payment of compensation. In view of the order of the sunset, the application seeking reference stood restore. My lord. Original one. However, the opposite party did not make the reference. There was no requirement for a claimant to file a fresh application seeking reference. However, upon receiving notice and such, the application for reference was once again made by the claimant. I am of the view that the application for reference has been made within 6 weeks of the receipt of notice, sunset, and also 6 months from the date of the collector's award. Well, it is neither here.
So what is the finding?
But they have not raised it, but finding is the one. Specifically, they have not raised in as far as the delay is concerned.
Whatever the case may be, the finding is there. He is now assailing this finding.
My lord. But in my respectful submission, my lord, if your lordship come to page 130, which is the written statement of the appellant hearing, my lord, state petitioner, my lord, they have not specifically raised the issue of delay, my lord. They have very casually, my lord, they have raised the.
You see, Mr. Krem, it is not an issue of whether they have raised it or not.
My lord.
Now the special judicial officer in the impugn order has specifically mentioned that issue.
My lord.
As far as delay is concerned, finding that there is no delay.
My lord. So in as far as the delay is concerned, my lord, I think the trial court, my lord, has dealt with the matter. Like, my lord, as I have shown to your lordship that the notice issued to me which is at page 42, my lord. This notice for collection of the award which was made to me, my lord, this was made in 2006, 4th August 2006. And I was asked to appear before the collector on 18/8/2006. On the same date, my lord, I have put my application for under section 18, my lord, for referring the matter to the special judicial officer, my lord. So in as far as delay is concerned, my lord, the special judicial officer had dealt with the matter, my lord, and finding has been arrived at, my lord. So the issue which has been raised by the petitioner in this particular FU, my lord, that there is a delay, a prolonged delay in filing the application under section 18, my lord, that does not stand, my lord, in my respectful submission, my lord. The other aspect, my lord, will, in as far as the rate is concerned, the only thing is, my lord, the cross-examination of the witnesses has not been annexed, my lord, in the paper book, my lord. Only the examination in chief has been annexed, my lord. Because, my lord, one very important thing is there, my lord. Even the witness of the present petitioner, my lord, has admitted that the award which has been given to me, 80 rupees.
But why is the paperwork not complete?
Only the examination in chief has been annexed, my lord. The first examination I have not found, my lord. My lord, will kindly see page 192 is the examination in chief. 198 examination in chief. First examination, my lord, because that's very relevant, my lord.
Nicely, it has to be complete in all respects.
In fact, my lord, we prepare and we have given copy to other side. The lordship made us that the papers are in order and made a fix for final hearing.
And that is why you expect the court to go through all this volume.
But I wish that my friend could have pointed out at a point of time if there is some documents are missing.
We have proceeded almost complete with the hearing now.
Because their own...
Because you see, you know very well, see, the first appellate court is to reappreciate the evidence and come to a finding based on the argument of the parties. Now what do I do?
But if lordship permits me and my friend thinks that those papers are relevant, deposition are relevant, madam, allow me a week's time to trace back from the record and place before me.
It's absolutely.
I can highlight it. From
you should have pointed out this lacuna.
I'm extremely sorry, madam. Because why I'm saying that, because the main witness of the appellant who was deposed before the special judicial officer, my lord, he himself on record has stated that the amount which has been determined by the collector It's not a market.
His witness has said that.
Absolutely, my lord.
But
And he's the chairman. He's the chairman of the bank, my lord.
Well, a week's time report may be, my lord, in this before this court.
The
I'll
court-
trace out those relevant.
court's
If my
already-
friend
the court's
point out
already
those witnesses, my lord.
My lord, he can file it by way of affidavit or by.
You have to file
Supplementary paper, my lord.
supplementary paperwork. This is the problem. See,
Well,
now,
I'm sorry,
next
I'm
time
sorry,
you come,
my
I'll
lord.
I forget what you have said.
On only 10 days time may be given, my lord. I'll do that, my lord. Without faith, my lord.
Heard Mr. H.L. Sangresu, Lariat Senior Counsel, appearing for the appellant. Also heard Mr. L. Kriam, Lariat Counsel, for the respondent number 1. 3. So, Mr. Kriam is for 1 and 2.
1 and 2.
1 and 2. However, in course of hearing, it is noticed that the paper book supplied by the appellant is incomplete in as much as the relevant in as much as the deposition of the claimants have not been enclosed in its entirety. Accordingly, on prayer made by the Lariat Senior Counsel, supplementary paperwork is allowed to be filed before this court. On prayer made, this is matter to 2 weeks.
Well, I do.
Wait, please, Your Lordships. Lordship, I beg to make a mention of item number 19, Your Lordship. Lordship, I pray for some accommodation, Your Lordship, in this matter.
Item number?
Item number 19, Your Lordship.
It's a writ petition.
Yes, Your Lordship.
What is
Yes.
the matter about?
Your Lordship, we have preferred this writ petition, Your Lordship, against the order passed by the learned Central Administrative Tribunal, Your Lordship, CAT.
You are for the,
I'm going to respond, Your Lordship. I have no objection.
how long?
Your Lordship, 2 weeks, Your Lordship.
On pre-made writ petitioner. Not objected to by respondent. Matters adjourned. List the same after 2 weeks.
Highly obliged, Your Lordship.
May it please Your Lordship. Your Lordship, I beg to mention items number 11, 12 and 13. These are connected criminal appeals, Lordship. Lordship, on perusal of the same and on research, Lordship, it has been noted that statements under 164 are missing, Lordship, from the paper book. We would need that, Lordship.
Your Lordship, I respectfully submit that it is a settled principle of law that statement recorded by the police cannot be used for any purpose, Your Lordship, except if there is any contradiction.
I'm mentioning 164, Lordship,
Oh, Your Lordship,
which my
there
friend
is-
might not be aware of.
164.
There is, Your Lordship.
It's there.
For that matter, Lordship, since it's been mentioned, even 161, do not admit it, Lordship, we will need a copy of that. It's not there in the paper book.
Your Lordship, section under 164 of CRPC, Your Lordship, of PW1 is there, Your Lordship.
It's there.
Is there.
Accused persons, Lordship.
This person.
Lordship.
Have their statement been recorded under 164?
No, Your Lordship.
Lordship, whether the...
You check the records.
Lordship.
Check the records and see if you have not enclosed in your paper book, and file a supplementary paper book.
Much obliged, Lordship.
Ms. Anjishila, the CAG has submitted that the paper book filed by the appellant is not complete, in as much as statement under section 164 of the accused has not, a copy of the statement has not been incorporated therein. The Ms. The same learned counsel for the appellant has submitted that the appellant will be allowed to recheck, and if necessary, supplementary paperwork may be allowed to be filed. Allowed. This is matter after how long?
1 week.
1 week. 1 week. Okay. And no, 2 weeks. So 2 weeks. Another week. And die. 2 weeks.
Much obliged, Lordship.
That is 11, 12, and 13.
11, 12 and 13, Lordship.
Same.
Lordship. Much obliged.
Hello, I beg to mention item number 17, my lord. My lord, I pray the matter will come up after 2 weeks, my lord.
No objection.
On pre-made the appellant seeking accommodation. Matter is adjourned. This is the after
2 weeks. 2 weeks, my lord.
2 weeks, 3, I think 3 weeks.
Deeply obliged, my lord.
There's too many in this.
Supplementary list, item number 1.
please, Your Lordships. Lordship, in this matter, we're supposed to file affidavit in reply, Lordship. I pray if Your Lordship can
Who's
kindly
to
find
file?
us. We're supposed to file, Your Lordship.
File a counter affidavit.
We're supposed to file a. We're
You
supposed to file a rejoinder, Your Lordship.
rejoinder? You have not yet.
Not yet filed, Your Lordship. I pray for some more time, Your Lordship.
The learned counsel appearing for the petitioner has sought for some more time to file the rejoinder to the counter affidavit filed by the respondent. We are appearing for all the respondents.
All respondents.
On premier, the same is allowed. Place this matter after 3 weeks.
Item number 5.
May I please, Your Lordship? Your Lordship, we are supposed to file a rejoinder in this matter, Your Lordship. Your Lordship, I'm praying for 2 weeks' time to file a rejoinder.
Same order. Kung kato ko previous order to change secretary. Filing of rejoinder. 3 weeks.
Much obliged, Lordship.
Item number 6.
May I please, Your Lordship? Lordship, as per the last order, we are supposed to file our paper book. I have already served the copy to the other side. We'll file during the course of the day, Your Lordship, the paper book.
Miss Learned Counsel for the appellant has submitted that the paper book is ready and may be allowed to be filed in course of the day. Pray allowed. This is matter for hearing after 3 weeks.
Oblige, Your Lordship.
Item number 7.
Lordship, I pray for 2 more weeks to prepare the paper book. It's yet to be ready.
Miss Learned Counsel for the appellant has sought for some more time to prepare the paper book. Pray allowed. This is matter of 3 weeks.
Much obliged.
Item number 8.
May it please, Your Lordships. Your Lordship, I pray for another 2 weeks' time, my Lord, to file the paper book, my Lord.
It will take 3 weeks time. It will take 3 weeks. It will take 3 weeks time so that the paper book will be ready by that time.
Yes. Yes, no, still Learned Counsel for the appellant has sought for some more time to prepare the paper book. Pray allowed that the paper book be filed within the next date fix. This is matter of the 3 weeks.
Shall you oblige?
Item number 9.
Yes, Mr. Upadhyay, where were we?
Lordship, we have completed the evidence of the PWs.
Your legal aid counsel here?
Legal aid counsel.
Yes.
Your Lordship, the exhibit 1 is the FIR that already I have read, Lordship. Exhibit 2 is the inquest report.
What page?
Page number 65 is the type copy.
65. Yes.
Lordship. Here, the inquest was prepared by the IO, and as per the inquest, Lordship, there are 3 injuries that has been pointed out. Point number 7,
Yes.
appearance of the injuries, if any.
Yes.
Cut mark on the throat. Number 2, left eyeball crushed. Number 8, injuries detected after removing the wearing apparels. Number 1, cut marks on the left lower abdomen, of which intestine bulging out. After that, Lordship, the Caesar list at page 67, the type copy. Now, PW 5 and 6 were the seizure witnesses.
Yes.
Caesar list, it reads as ISIMK Marak of Marang PS do hereby today the 4th June 2015 at Sodadek village seize the below noted articles from the possession of Srimati Tirit Maula, son of, it is daughter of late Shai Kurba of Sodadek village, PS Mairang, in connection with Marang PS case number 33-6-15. The seizure is made in the presence of the below signed witnesses. Description of seized items. Number 1, 1 khasi dao with handle 2 feet approx. Number 2, 1 iron rod 1.10 feet approx. Witnesses Ping Kharkhongor, Sardar Umpedem. Number 2, Singain Lut L. Nongleit. Here, Lordship, the signature of IO is not there, who is supposed to be the author of this seizure list. It can be compared from page 66.
Since the signature of the IO is not there, would that make the seizure list inadmissible?
And this cannot be taken into consideration. That is point. That is that goes in favor of the accused.
In due course, you can state the law.
Yes, and that the concerned IO who had made the seizure also, he had not exhibited this seizure list.
This was exhibited. Seizure list is exhibit 3.
Exhibit 3 is the seizure list. Yes.
So
this was proved through the PW 5 and 6. They were the seizure witnesses. Seizure witnesses has proved this document. Now, Lordship, page number 68 is the postmortem report.
yes. Page number?
Page 68 to 77 is the postmortem report. 78. Is the postmortem report. Here, now page number 77. Page 68, I will read, Lordship.
Yes.
Whence brought village and Thana 4/6/2015. The incident is of 3rd June 2015. The dead body was brought to the PHC on 4/6/2015 at 7:15 p.m.
Yes.
Now the injuries were discussed on page 69. Condition of subject: stout, emaciated, decomposed, etc. Average build male. Position: dead body seen lying in supine position with lower limbs extended, upper limbs extended, and head facing towards right side with mouth slightly open. Face congested with blood covering it. Pool of blood seen in and around the dead body. Wounds: position, size, and character. Penetrating wound 2.5 centimeters over the right part of the forehead, penetrating deep into the brain matter. Penetrating wound over left eye, penetrating into the eyeball deep into the socket. Number 3. Penetrating wound 3 centimeter over back of the head, optical region, penetrating deep into the brain matter. 4. Chop wound 6 inches over artery and lateral part of the neck, revealing the neck, soft tissues, the cut vessels, bronchi partly chopped, exposures, and page 70 extended posteriorly. Step wound penetrating with dragged margin 7-inch over left hypochondrium and left lumbar part of abdomen, revealing the intestine, including perforated intestine and torn peritoneal lining with facial matters leakage from perforated intestine. Now, cranium and spinal canal, page 71. Penetrating wound 3 centimeter over back of the head, optical region penetrating deep into the brain matters. Membranes torn, brain and spinal cord, brain matters comes out from the wound over the optical region. Thorax, page 72. Walls, ribs, and cartilages, no abnormality detected. Thorae, no abnormality detected. Larynx and trachea, cut at the arterial part of the neck, revealing both the bronchi. Right lungs, no abnormality detected. Left lung, no abnormality detected. Pericardium, no abnormality. Heart, no abnormality detected. Vessels, no abnormality detected. Number 73 page. Abdomen, step wounds penetrating with dagger margin 7-inch over left hypochondrium and left lumbar part of the abdomen, revealing the intestine, including the perforated intestine and torn peritoneal lining with facial matters leakage from perforated intestine. Torn mouth and esophagus, pharynx and partly chopped esophagus seen over the chop wound on the lateral part of the neck. Stomach and its content, no abnormality detected. Small intestine and its contents, no abnormality detected and contains digested food particles. Large intestine and its contents, perforated and facial matters leakage present. Now abdomen, liver, no abnormality detected. Spleen, no abnormality. Kidney, no abnormality detected. Bladder, no abnormality. Organs of generation, no abnormality detected. Muscles, bone, and joints, the injuries, absent deformities disease and deformities absent, fracture absent, and dislocation absent. More detailed description of injury or disease. So, the detailed finding of the examination. On examination, number 1, penetrating wound 2.5, which has already been read, Lordship. Now the findings is at page 77. Opinion of assistant surgeon, sub-assistant as to cause of death. My opinion based on postmortem examination done. Number 1, the manner of death is unnatural, homicidal, and the cause of death is hemodynamic shock due to hemorrhage, severe bleeding from multiple injuries on his body, and number 3, these multiple injuries may be caused by heavy sharp object and fairly heavy slender object. So this is the postmortem. After the evidence, on appreciation of evidence, the court has the judgment is from page 81 onward. It runs to 31 pages. This.
As far as the post-mortem report is concerned,
yes,
you have no grievance against it.
No, Lordship.
You have accepted it as it is.
Yes. Because that cross-examination has been declined.
Oh, declined.
May I read that judgment, or Lordship, or take it to the relevant points?
Only the part which you feel is not proper or is against you.
Lordship. So, Lordship, after the trial, what was the issue before the trial court for consideration is at page 100.
Yes.
Para 45, page 100, relevant is para 45. Issues for consideration. Para 46. After perusal of the evidence on record and the arguments presented by both the defense counsel and the prosecutor, this court frames the following issues which are required for consideration. Number 1, whether the accused person, Srimati Tirit Maulang, killed her brother, late Rikit Maulang. Number 2, whether the accused person, Srimati Tirit Maulang, has any intention and motive to commit the murder of her brother.
The pagination is not correct. Mine appears at page 126. You can correct it. Here also 126 is there, and then 100 is there, and 20 is there. So many pages.
Yes, so 126 has been cut for 100 because earlier in the first round judgment was part. That was also a part of this paper book, so that has been removed after later on.
You can make the necessary correction.
Yes, para number I am tell you.
If it is limited to only one page, that is fine, my lord. But if it goes on and on, my lord, it will be a bit difficult to refer.
You don't have 100 the number 100 in your
26.
I have 100, but he is referring to page 100.
Yeah.
But 100 is before the. He is at page 126, my lord. So, my lord, all the pages will be jumbled up. When I refer to the pages, my lord, it will be completely different.
Then you correct it.
You will have difficulty in making his reply.
Yes,
exactly.
Here we have two marking, we can make it out.
Yes.
But in his copy there seems there is only one.
This is this paper book is prepared by the registry, lordship. Probably his copy is left out from this correction. That is so.
You can make arrangement.
Yes, yes, lordship.
You file a petition against the registry. Next week then.
Next week, lordship.
First Mr. S.D. Operator, Learned Legal Counsel has continued with the argument, but could not complete the same today. On premier, this is matter on 12. Today's 12.
Today is 12. 19 it can.
This is matter 19.
19, lordship.
Item number 10.
Wait, please, Your Lordship. Your Lordship, this is also a POXO matter, Your Lordship, but the conducting counsel is currently not available, Your Lordship. Your Lordship, I pray for a week's time, Your Lordship.
On premier ready appeal, this is matter of 3 weeks.
Right, Your Lordship.
Item number mentioned earlier.
Your Lordship, I assume that the conducting senior would come, Your Lordship, but it seems, Your Lordship, an emergency has happened, Your Lordship, so he cannot come. My apologies, Your Lordships.
Item number 14.
Please, Your Lordship, this matter, in fact, the argument is already concluded on last year, no, September, 10 September, but I was given the opportunity to submit certain authorities in support of my case. The thing is that my main ground here is there is a manipulation of a document. The exhibit here has been manipulated. The documents which are supplied to me at the time of framing of charge, was not exhibited. That is a very important document, which is a birth certificate. Now, when the evidence was taken up in 2019, charge was framed 2017. In 2019, when evidence was taken, some other birth certificate was brought. And there's nothing on record where the concerned court had passed any order to make those changes and all. So now that document is in question. So now what I've done is...
You should have raised that issue before the trial court.
Exactly. But again, that was not brought here. I've noticed it now. Now this is also part of the paper book where those documents are enclosed here in the paper book. And also the orders which were passed at a time when the evidence was taken. There's no such orders to that effect where these changes were made. Certain procedure was followed, no procedure was followed. Now, to find out whether this particular document which was exhibited, whether it is a genuine document or not, I had filed one RTI requisition. I have not received a reply to that. So if I may be allowed some more time to get the response to that RTI. As I've questioned the authority as to under what provision of law have they made those changes, they have not responded.
POXO case?
Yes, sir.
So you're pleading juvenility?
Sorry?
Are you pleading juvenility or?
No, that's not the case. It's just a mistrial that has been committed in this case. Because the document which was exhibited was not at all supplied to me, was not at all, no order was passed to that effect to make those changes. And at the time of framing of charge, it was not there.
So the framing of charge is completely
It was introduced in
much
course of
later.
trial. No,
Much-
in course of trial. See, when
Yes, in the course of trial.
when the relevant witness was
Yes.
Yes. Had deposed.
Yes.
So that document was introduced.
Yes, that document was
At that
introduced
point
and
of time,
exhibited.
at that point of time, you had
No.
the opportunity to cross-examine him.
Exactly. But that was, I understand, Your Lordship, but that was noticed when I was preparing this appeal. I noticed that anomalies. Lordship,
You mean to say that it is because of that lacuna?
Yes.
The whole, the crux of the
Has been vitiated.
whole.
The trial court had followed procedure, calling in the investigating officer under 173 to do further investigation. I would have not objected, Your Lordship. That procedure was not followed. It was just brought on in the court and exhibited, and that copy was not supplied. Nowhere in the order sheet there's any proof to show that document was given to the accused or the counsel for it to examine and to cross-examine the witness. Nothing on record. It was just brought and exhibited. That's it. The date of issue of that birth certificate, there are two birth certificates here in the record. One is of
Birth certificate of whom?
Of the victim. There were two birth certificates. At the time it was given to me a copy. The birth certificate of that one was given to me, and the charges were framed in 2017. In 2019, when the evidence was taken, some other birth certificate had come of 2019 issue.
Exactly. Now, even if we look at that matter in isolation, whether the birth certificate, states, suppose one birth certificate states 11 years, and the other birth certificate states 13 years.
As for the date of birth, there is no dispute. The name of the father has been changed. The name of the father which was there in the birth certificate which was supplied to me along with the charge sheet, and the birth certificate which was exhibited, the name of the father was completely changed. What is the reason? That was not given by the trial court.
How would that really affect your case? And if you want to, you can raise this issue and convince us with what the law says on this.
Yes.
On payment by the learned counsel for the appellant, this is matter of the 3 weeks.
Yes. Pleasure.
Item number 15.
This is the
Please, Your Lordship. This is appeal against conviction, Your Lordship. May I start, Your Lordship?
This is not that plea.
Of Juventus, that is next item, Your Lordship.
Next item. POCSO?
Yes, Your Lordship. POCSO.
May it please His Lordship. Lordship, here we have filed our substitution application, Your Lordship. Your Lordship, if Your Lordship may recall, Your Lordship, on the last occasion, Your
Mr.
Lordship.
Chanda had appeared, Lordship.
Your Lordship, but then the miscase.
There's a prayer from our side if the notice could go to the wife of the deceased respondent, Lordship. Because the respondent has expired and he has to be substituted by his wife.
This is a writ petition.
This is a writ petition.
Why you filed a petition under the CPC? Order 22, Rule 3.
What is it?
This case is under Order 20, Rule 3. Whether CPC applies to writ petition. Reply. Court has asked you a question.
Your Lordship, since this is a substitution application, Your Lordship.
Whether CPC applies to civil proceedings.
Order 22, Rule 3.
Yes, Your Lordship.
Up to Section 141 CPC. You do not have a book.
Yes, Lordship.
And then come to the explanation down below.
Yes, Lordship.
You see, when you file such application,
Yes, Lordship.
even if you rely on CPC, the wording should be an application in the nature of, in the nature of so and so, then that would be acceptable.
I'm apologies, Your Lordship.
Hard best. Okay, we're counsel for the petitioner, Public Union of India, who has submitted that on coming to know that the sole respondent has expired, it is therefore necessary that he be substituted by his legal heirs and legal representatives. Where are the names of the legal heirs?
Your Lordship, it's Veena Dhondial, Your Lordship.
He is survived only by his wife. Where is it?
Your Lordship, if I can take your Lordship to page number 6, Annexure A, Lordship.
But in your pleadings, you should have stated that so and so is deceased. He is survived by so and so.
Your Lordship, we have stated in the third line of para 2, Your Lordship, that this fact was brought to the notice of the applicant by the opposite party herein, who is the wife of Sri Ramesh Chandra, Your Lordship. Write her letter dated 24.
True. But she is not the only,
Yes, Lordship.
He may have sons, daughters,
Yes,
grandson,
Lordship.
grandchildren, great-grandchildren.
Yes, Your Lordship.
See, because this is very tricky.
Yes, Lordship.
If you make, you substitute any particular person,
Yes, Lordship.
and matter is decided, either for or against, and some point of time somebody else will come and say, no, we are the legal heir. You should ascertain as to who, because legal heirs means we 1, 2, 3, 4, or only one.
Yes, Lordship.
Coming to on. Has expired on when?
27/11/2024, Your Lordship.
7/11/2024. The wife being the legal heir of such deceased respondent, therefore, prayer is made for issuance of notice upon her to enable her to join proceedings if so desired. In this regard, the death certificate of the deceased respondent has been annexed as Annexure B in this petition. It is I didn't do the next. Prayer is made accordingly. On consideration of the submission and prayer made, we are inclined to allow the petition. Accordingly, let notice be issued. The same is returnable within 2 weeks.
Notice.
How your presence currently?
I cannot even. Just want to price this court, Lordship. Otherwise, I cannot. Without Vakalanama, Lordship, I can.
Oh, that's for substitution. Issue notice. Come on, petition allowed. Issue notice returnable within 2 weeks.
Since you cannot appear,
Cannot appear.
we are not allowing your substitution petition at that stage.
Roger.
Let the notice of the miscase go to the party, then we will see.
Roger.
Highly obliged.
Yang em. Absent. Absent kau. Oh ya.